All right, so here we are. I am joined again by Professor Swartz, my friend, who's a former judge here in Florida, and we have been talking about the Michael Flynn case, which of course is big in the news. The Department of Justice suddenly deciding that maybe they should drop this matter after all, that he lied to the FBI. No real question that Bill Barr has his paw prints all over this, um, and maybe some political implications here, but. Something strange happened on Michael Flynn's on his way to freedom, or so he thought. Which is the Judge Sullivan, who seems not to be a person to be trifled with, has appointed a former federal judge named John Gleeson to argue against the government's motion to drop the case, and said, by the way, while you're at it, give me a recommendation whether Flynn committed perjury and therefore should be held in contempt of court. So, what looked like it was maybe the end of Michael Flynn's trouble suddenly looks like it might just be the beginning. So, what's this all about? What's this? Why is he appointing some former federal judge, who, by the way, Jeffrey Toobin from CNN, I saw said is the finest lawyer he's ever come across in any context in his entire career. Why is Sullivan appointing some former judge to argue that he shouldn't dismiss the case? Shouldn't Judge Sullivan just dismiss the case if the government wants to dismiss it?
Okay, just as a little background, in most cases in federal court, the defendant is indicted. And so therefore, as we learn, as people learn in criminal procedure, the indictment is important because it is a barrier between the eccentric judge and the overzealous prosecutor. It is citizens who make the decision as to whether someone should be prosecuted based upon a common sense determination of probable cause, whether that person committed that crime. In this particular case, on the verge of being indicted for a really numerous amount of counts, Flynn entered into an agreement with the government to an information, and I have it here. This is the information in the Flynn case, which is a document signed by the prosecutors alleging the offenses. And with that, there must be a waiver, which there was one, signed by Flynn agreeing to be prosecuted by way of information because they had already entered into a plea agreement. He had agreed to cooperate with the government, be debriefed, give information, and in return for which this was the less onerous offense for which he was going to be charged. There were very serious offenses that could have gotten him possibly even decades in jail for. So as a result of which, plus his son would have been charged. That was the big hammer on him. At the time that was done, and the very next day when after the information was filed, this document, which is known as a statement of the offense, which is an outline by the government of exactly what Flynn did, was filed with the court. And on the last page of this document is Flynn's signature and the signature of his lawyers.
Can you hold that up a little higher?
Sure. Okay, it has his signature. It acknowledges the truthfulness of everything that's in there, acknowledging he committed the criminal offenses. He signs it, and his lawyers sign that, in fact, they've reviewed it with their client. So he understood the import of this document. And in this document, he belies the one statement that's made by the government in their motion to dismiss, and that was that the statements made by Flynn were not material to an investigation. He was the target of the investigation. How can anything he say not be material? What's missing from the thought process is the one thing that people don't talk about. The real subject of all of this was violations of the Logan Act by the president-elect of the United States, that being Donald Trump, that was interfering with our international and foreign policy, okay, and using Flynn to do it. And as a result of which, whatever Flynn did while he was in the White House, and that is lying to the public and lying on television and lying to everybody else about what he did or did not say to Kislyak, who was the Russian ambassador, okay, was done in protection of or at the behest of the President of the United States. That's something people are not saying, okay? And that's the thing that at this point Trump is most afraid of Flynn being cooperative and being incarcerated, is that he will say what he knows happened in the White House, and that could include the president then president-elect and then president of the United States, and what he said. So that's where we stand. And so now the question before Sullivan is, did he lie to me as the judge when he entered the plea and signed these documents, or did he lie to the FBI? It's not over and done with. Gleason could recommend or could argue, and Sullivan could accept. Okay, and Sullivan, by the way, has been described as an Obama appointee. He is not an Obama appointee. He is a Reagan appointee. Okay, he's been on the bench that long, and he is no one to mess around with. Okay, he's proven that in the past. So what we have here is John Gleason coming in and arguing you shouldn't dismiss this. And so Sullivan has to make that decision. Sullivan has seen what he could do, and he's throwing it out there. If I do dismiss this, you're still answerable to me, Flynn, because I'm going to start contempt proceedings. He won't refer it for a perjury count under a statute because the government will never prosecute it. So he wants to go forward with contempt for lying to him, which is his inherent power. It's not based upon any statute. And because it's not a statutory crime, Trump could not pardon him from a contempt citation. As a result of which, if he's found in contempt and Sullivan puts him in jail, Trump can't let him out. And Gleason is a former judge. He is clearly the right guy for what Sullivan wants him to do. He was a judge in a case involving HSBC Bank, which was under a deferred prosecution agreement of the bank. Basically, he wrote as follows: the proceedings necessarily involve the judicial branch, and the law provides that the court, not the executive branch, decides whether an indictment be dismissed. Okay? And the responsible exercise of that authority is particularly important where a defendant's plea of guilty has already been accepted. Government motions to dismiss at this stage are virtually unheard of. Okay? So he basically said, no, you don't have the ultimate power. And that's the key here. The government can't just dismiss. They must seek legal court by rule.
Right. And that was a mistake on the part of the Department of Justice and I think the media. The media jumped on this as though Flynn is off the hook because they didn't understand that this is ultimately a decision that's going to be made by a court, whether at this late stage of the game. And I saw that Gleason also wrote an op-ed piece. I think that's probably one of the things that got Judge Sullivan's attention, saying that this is unprecedented for the Department of Justice at this stage, in a way that again looks so political on the surface, to move to drop a case and just talk about we don't have much time left, but from the perspective of a former judge, I think one of the things that's interesting here, we have an adversarial judicial system, and one of the reasons Gleason has to get involved here, or one of the reasons Judge Sullivan had to get somebody involved here, is because you can't decide an issue like this with only one side presenting their side of the case. He had to find somebody who's capable of arguing against dropping. Because I think people are wondering why does Judge Sullivan need some other former judge, right, to come into this and tell him what to do? That's not what he's doing. What he's doing is he's trying to hear a balanced argument, of opposing sides because of our adversarial system. Anything to add to that?
Well, yeah, I can add to that. First of all, I've actually seen lawyers lose unopposed motions, usually on technical grounds, but I've seen them lose unopposed motions. But to the same extent here, I think that what to a great degree, if he is inclined to deny the motion, Sullivan wants there to be a record, okay, of why he's doing it, in the context of there is opposition to it, there are reasons for it. He does not want to be deemed to be an adversary to Flynn, because if there is no record for him to operate on, Flynn, after he denies the motion, will move to disqualify him in the context that he's an adversary. And he might end up with a judge who will listen to his arguments again and dismiss the case. So he understands the nuances of what he's doing. And he doesn't really need Gleason to tell him what to do. He needs Gleason to make a record for him as what he should do. Okay, there's no question that this whole situation is bothering Sullivan in the context that I have been manipulated. This court has been manipulated. What happened to the people that were prosecuting this case? Why am I getting political appointees signing this motion? And by the way, he probably could have demanded that the Attorney General of the United States come in and explain the actions of his department. He does not want to get that adversarial with them, so he's not doing that. But he is going to force him to defend the decision.
Excellent. Well, we're up against the clock, but that was extremely informative. I think hopefully people come away from this with a better understanding of what's going on here. But to recap, we have a new player in the Flynn case. It's former Judge Gleason. He is going to argue that the Department of Justice should not be allowed to drop the case against Michael Flynn. And Judge Sullivan, who's sitting on the case, also asked for a recommendation about perjury and contempt. And
when we come back another time, we can talk about the difference between contempt and perjury and why the judge might want to go the route of contempt as opposed to perjury.
Right. Essentially contempt for perjury, right? But doing it under his contempt power. And just because we're out of time, but bottom line, because he doesn't want Donald Trump to be able to pardon him for that. And Donald Trump cannot pardon somebody, right, for inherent contempt of court.
That's correct.
Right. All right. Well, thanks for this, and we'll be back to chat more. But be safe.
You need to make longer. We need to be able to do a longer thing here. Okay.
Well, we need 1,000 subscribers for that, so we need to work harder.
Okay. Okay. Everybody who's watching this, call somebody and tell them to subscribe, even if they don't watch anymore.
Like and subscribe.
Okay.
Like and subscribe. Yep.
Okay.
All right.
Have a wonderful day.
You as well.